My name's Samantha Cruz. I am a paralegal. I'm also the trial paralegal here at the firm. I support the attorneys here by preparing for trial. I'm responsible for exhibits and witnesses, coordinating the trial schedule, reaching out to experts. I assist the attorney to make it easier for him so he can worry about speaking to the jury because they're in and out of court. I have the primary contact with the clients on a day-to-day basis. I get to be with them from the start of their case, when they come in for the first meeting, to the end of their case, should we go to trial or facilitation. I find out their background, where they're from, what schools they went to, how many kids they have. My job is never boring. I think that everybody here really cares about our clients and the outcome that we get for them, and we want to do the best job for them. So I think that's what makes us different.
Brain injury cases. And what sets us apart from other firms across the state is that we recognize that brain injury cases can often be subtle. Sometimes brain injury cases are obvious. You've been knocked unconscious, you may have had a direct head strike. But in our experience in handling traumatic brain injury cases, we call them TBIs, we've found that someone who suffers a minor TBI may not even be aware of it. They might be aware only of a change of personality. They might be aware that they've been crying. They might be aware that they're emotionally agitated. We recognize those symptoms. In handling a traumatic brain injury case, I have two roles as an attorney. One, of course, is to get you the maximum compensation. But the second role is as important. We want to see you get better. And we have connections, for instance, to the Brain Injury Alliance of Connecticut that offer support groups, that may offer you assistance, that will direct you to.
Hey everybody, it's Carol Bird here, author of The Son I Almost Gave Away, and I want to tell you guys something. I'm just talking to one of my friends, and we were talking about how we only really like and are attracted to kind of like super weird people. And when one of my friends was in the psychiatric center, she was being treated. She was going through a lot of like depression and suicidal issues, stuff like that. I noticed that I felt more at home in that little living room area with all of the people that were like, being institutionalized for these like mental problems than I feel around pretty much anyone else. I felt right at home there. So I'm not sure what that says, but I actually was, once she was discharged, I wanted to like sneak in, and actually I did sneak in once with my kids, so that way I could go like socialize with all the other patients, because I just felt like they were more interesting and fun, and to me they were more normal than what normal people are. I don't know, I'm kind of scared to say this in public, but I think I do fit in more in the culture of like an institution where people are, being treated for all different sorts of like mental illnesses and problems. I think I fit in better there than I do into like society. So anyway, I have a question for you guys. Do you think that people who have extreme mental illnesses should be allowed to decide when they get discharged from the hospital? Yes or no, and explain why in the comments below. And really quickly, before I let you guys go, I want to let you guys know why I do these vlogs. And I am a vlogger because I have lived through being an autistic female and going through the depression and the suicide and isolation, and I do this because I want to help other people not have to go through that. And so if you want to be part of that mission to decrease the tenfold suicide rates in the autistic community, you can play your part just by subscribing and sharing this video, leaving a comment. All these things help with my YouTube rankings. So yeah, If you do subscribe, you can hit the little bell there, and anytime I get a new video, you will get a notification so you can watch it. Bye guys, it's Carol Bird, author of The Sun I Almost Gave Away.
Jim Castaneda was a boatswain's mate first class in the U.S. Navy when he suffered 2 strokes while on active duty.
And the way I fought it is having somebody like Sancho right next to me, pushing his own endeavors, and it helps me.
During the Pacific trials, Jim participated in track and field.
Well, the discus event was actually phenomenal. It was pretty exciting.
Jim also achieved another goal off the field when he was honored at a ceremony on Ford Island.
Bosun mate Jim Castaneda.
It's beyond words, and I'm gonna cherish this, of course, forever.
At the end of the Wounded Warrior Pacific trials, Jim Castaneda received the first medallion of the competition.
Their capacity to grow despite trauma, to compete despite injury on a daily basis, they offer us all a role model of the human spirit and determination.
Petty Officer Jerome Johnson, Honolulu, Hawaii.
Demonstrative evidence is evidence in the form of a representation of an object. This is, as opposed to, real evidence, testimony, or other forms of evidence used at trial. Examples of demonstrative evidence include photos, X-rays, videotapes, movies, sound recordings, diagrams, forensic animation, maps, drawings, graphs, animation, simulations, and models. It is useful for assisting a finder of fact finder in establishing context among the facts presented in a case. To be admissible, a demonstrative exhibit must fairly and accurately represent the real object at the relevant time. See Federal Rules of Evidence 901, 902, and 1001-1004 for an example from United States law. Other examples of demonstrative evidence include case-specific medical exhibits, colorized diagnostic films, general anatomy and surgery exhibits. These forms of demonstrative evidence are commonly used as a personal injury lawyer resource. Demonstrative evidence with dramatic impact can maximize the value of a case by effectively depicting catastrophic/traumatic injuries, complex surgical procedures, surgical mistakes, or summarize injuries suffered by an individual. These examples of demonstrative evidence are used for settlement conferences, arbitration, mediation, medical expert depositions, and trial presentations. In American jurisprudence, demonstrative evidence, like any other kind of evidence, must be relevant. At this point, the proponent of the demonstrative evidence can either try to get the evidence admitted into the official record of the case, or can choose to use the evidence as merely a prop. If the proponent of the evidence wants to have the evidence included in the official record of the case, the proponent will first ask for the evidence to be marked by the court for identification purposes. After the evidence is marked for identification, the proponent of the demonstrative evidence must lay a foundation. It is at this time that the relevancy of the demonstrative evidence is usually challenged. Laying of a foundation explains how the demonstrative evidence relates to the facts of the case and establishes the evidence's authenticity. Once the foundation is laid, the proponent may ask to officially move the piece of evidence into the record where it is marked as a full exhibit. If the evidence is marked as a full exhibit, the jury may refer to the evidence during deliberations, and in most jurisdictions the jury may examine the evidence during deliberations. If the evidence is not marked as a full exhibit, the jury cannot do these things. As a matter of courtesy, the proponent of the demonstrative evidence generally shows the piece of evidence to the opposing party before marking it for identification purposes. In criminal cases, certain kinds of demonstrative evidence are subject to mandatory disclosure under the case law governing discovery.